Well, a good family solicitor should explain what the various options are and which might be the best suited for their particular case. But if they don't, please ask them to explain. There is no one size that fits all, so never just one approach to reaching a resolution. And there are several options. Mediation perhaps is the best known form of out-of-court dispute resolution method and can also be used in combination with a number of options. A mediator is impartial. They'll help work with the couple to help them identify the issues and where compromises can be made and help them try and reach an agreement. It is a very flexible process which can involve the parties discussing matters directly with the mediator in the same room, or if that isn't appropriate, the mediator can use shuttle mediation to travel between them. They remain in the different rooms, but the mediator will help the conversation continue. It's usually advisable for the parties when they're going through mediation to have their own solicitors provide independent advice following the sessions themselves to help them make those informed decisions, although in certain cases they can be more directly involved. Integrated mediation perhaps is one example, also known as lawyer-inclusive mediation, as well as hybrid mediation and variations, and can involve the participation of other family law professionals and experts to give advice and support during the sessions themselves. Now, hybrid mediation is slightly different in that it's agreed at the outset that the mediator will only share information that the other side have agreed to disclose. This can mean that the mediator has separate and confidential meetings then with each party. Now, an alternative mediation is a collaborative law process, and this may be suitable for the more complex cases where the parties, together with their own legal advisors, engage in negotiations. Now, each will instruct their own collaboratively trained lawyer, and the four of them will sign a participation agreement committing to resolve the issues without going to court. And this provides the incentive for an agreement to be reached. Negotiations invariably take place through a series of face-to-face meetings, similar to mediation, and again making the process as efficient as it possibly can be. There's also the option now for a couple to instruct just one lawyer under the new one couple, one lawyer process. Now, this is where the lawyer will help guide them both towards a final outcome, whether relating to financial issues that arise following a divorce or separation, or the arrangements relating to their children, or indeed both. And finally, don't forget that solicitors are skilled in negotiation, and the vast majority of family lawyers will do what they can to help clients keep matters out of court and help broker those solutions. So if the parties' joint aim is to reach an outcome together, this could be an appropriate solution. So the lawyer will help guide them both towards a final outcome. Maybe that's in relation to a financial settlement on divorce or separation, or it could be the arrangements that need to be worked out for their children, or indeed all of those. There can be many advantages to this process. Firstly, it provides a single source of advice aimed at their joint benefit. It helps them understand the law as it applies to their circumstances so they can plan and make decisions together. It can therefore empower the couple to craft their own tailored solutions in a very bespoke way. If the terms have been discussed already, then it can help the couple understand whether those terms are reasonable. And of course, it can help make those arrangements legally binding. As a process, it can be more cost effective than instructing two separate lawyers, and of course it can be a quicker way of enabling the parties to move forward with their lives sooner than would be the case through litigation. The vast majority of family lawyers will do what they can to keep matters out of court and help clients broker those solutions, but there are going to be occasions when an impasse is reached. Now, you'd hope that some of the non-court options spoken about have helped at least reduce the number of issues in dispute so that litigation really does become the last resort. Litigation, however, need not involve making an application to the court, and arbitration can be a really useful tool. Arbitration involves the parties appointing an arbitrator to decide their case in the same way that a judge would in court. However, arbitration proceedings can move much more quickly and flexibly than the court system. It's also private and therefore not subject to any press intrusion. Arbitration can deal with children matters as well as financial disputes, enabling complex cases to be settled in a matter of weeks rather than months, if not longer. And of course, the arbitrator's decision is binding and therefore enforceable. So this has been a very brief overview of the non-court options in family disputes, but if you need any further information or help, please don't hesitate to contact either myself or Waitmans directly.